I was born in Zimbabwe. I grew up in Zimbabwe in a village.
You mentioned that you were born in Zimbabwe, and just to make sure that we comply with the constitution, which requires judges to be South African citizens. You are a South African citizen.
I am a South African citizen, CJ.
Yeah, I thought so.
Yes, I am.
When did you acquire that citizenship?
2016, 2017, somewhere thereabout. Right. But having said that, I'm not aware of any matter that I've worked on where there were foreign nationals involved. Maybe they were, but if the papers do not refer to the fact that they're foreign nationals, I have no way of knowing that they are foreign nationals. But what I did indicate in my questionnaire is back in the day, there was a discrimination matter that I was requested to assist with through the SASLO Pro Bono office involving foreign nationals. In
a move that shocked many on social media, a Zimbabwean lawyer applied to be a judge at the Labour Court, a job that could easily be done by a South African, and seemingly, the JSC wants to appoint her over the other South African candidates who are fully natives.
Good morning, Ms. Kanditse.
Morning, Commissioner.
I must say, Ms. Kanditse, your journey is an inspiration to many young women out there. At the age of 46 years, you've already attained so much for yourself. Now, please briefly tell us, who is Mr. Biwa Cecilia Kanditse, starting from your childhood ages?
Starting from my childhood age, so I was born in Zimbabwe. I grew up in Zimbabwe in a village. And then went to boarding school for my high school, and then went to Fort Hare University tertiary education in 1998. I don't know whether that covers what you want me to cover in your question, but in a nutshell, I come from very humble upbringing, and I've heard to work my way up to be where I am today. I don't know if that answers the question.
No, I think I'm happy with your response.
Thank you.
At least we do have the gist now.
Thank you.
Who are you? Now, my next question will then be, by its nature, the labor disputes are adversarial. But alternative dispute resolutions mechanism, like the mediation and arbitration, they do play a crucial role in the labor law. How do you see the role of the labor court judge in promoting effective dispute resolution beyond litigations?
Yes, I do think that as labor court judges, we definitely do have a role to play, and I will speak from experience. I've heard files before me, and I go through the files and I go through the issues, and I then say to the parties, it seems to me that the real issue is actually issue X, and it seems to me that if the parties can go down the passage and have a conversation about it, you're actually able to resolve the matter. And in my experience, that has actually worked. Parties come back to me and say, thank you, Judge. We've actually had a discussion about what you proposed, and we've resolved the matter. Mediation, I know it's not provided for in the Act, as I can recall. I think that's a function that's offered by the CCMA. But I do know from many years back, when I was involved in some strike-related disputes, that we would appear before a judge in the labor court, and the judge would propose that the parties explore mediation before resorting to litigation, and it worked in some of those cases. So I think mediation definitely has a role to play in resolving labor disputes.
Okay. No, thank you very much, CJ. No follow-up.
Thank you, Commissioner. You mentioned that you were born in Zimbabwe, and just to make sure that we comply with the constitution, which requires judges to be South African citizens. You are a South African citizen.
I am a South African citizen, CJ.
Yeah, I thought so.
Yes, I am.
When did you acquire that citizenship?
2016, 2017, somewhere thereabout.
All right. Thank you, Ms. Kandize.
Thank you.
President Mulemela.
Thank you, CJ. Good morning, Ms. Kandize.
Good morning, President.
Have you ever been in a situation where you were involved in a review application and discovered that the record was incomplete? And if that is the case, how did you deal with it?
Yes, President, I know that there was a time when the case authority suggested that if an applicant places or asks for a review application to be enrolled in circumstances where the record is incomplete, there was a time when the approach of the Labour Court used to be to just dismiss the matter. But I do know that with I think the practice manual from 2013, there were then provisions in the manual to the effect that if the record is incomplete, then the judge president can be approached for directions on how the matter must be dealt with. If it's possible to reconstruct the record, that's an option that can also be explored. But if the record is necessary for purposes of deciding the review and it cannot be reconstructed, then there are matters where matters that have been remitted to the CCMA or the Bargaining Council. So when you ask about my experience, I do know that I think last year, 2024, I had a matter before me where the record could not be reconstructed at all, and the issues that were raised in the review application required me to have regard to what was in the record, and I then remitted the matter back to the CCMA for a fresh hearing.
Or for a fresh hearing?
Yes.
Okay. Thank you. Okay, sorry, CJ, just a follow-up. And what would you do if only part of the record is missing, not the entire record?
So, President, it depends on the issues on review. If it's an issue that you can decide based on the record that's before you, then I would decide the matter based on that record that is before the court. But if I'm not able to decide the grounds for review based on the record that's before court, then I would first prize ask the parties to see if they can reconstruct the record, and if that is not possible, then I will consider remitting the matter to the CCMA or the Bargaining Council. So the answer is it depends on the issue. There are some issues that you are able to decide on review without a record, but there are some issues where your decision has to be supported by what is in the record.
So if the record...
Good morning, Commissioner.
Just one question. Where, for instance, the court, the Labour Court, finds that a hopeless case is being pursued, especially by those who are in the senior echelons of state administration, and that weighs very heavily on their juniors. And the court arrives at that determination. Do you think that it is justified that the court can order that the cost must be borne by those that pursued that hopeless case? Thank you.
Thank you, Commissioner. The answer is definitely, and especially where people are legally represented, and they still insist on having a matter litigated, which a court describes as hopeless. I've got no question, I've got no doubt in my mind that people must be penalized with court orders to discourage other litigants from pursuing hopeless cases.
Commissioner Hassan?
Thank you very much, CJ. My name is Commissioner Fasiya Hassan.
Thank you, Commissioner.
Thank you very much. I have a different question. In your papers, you spoke a lot about your extracurriculars and work outside of the legal fraternity, related to you being the chair of the Cape Town Rape Crisis Center, as well as mentoring a young black woman attorney. So I'm just interested if you could maybe expatiate on some of this work around gender empowerment and some of your activism work more broadly, and how it, positively or negatively, may affect your role as a potential judge in this particular Labour Court. Thank you.
Yes. Thank you for that question. I must say it's a question that I always anticipate when I sit in these matters. But I can assure you that I've probably written 3 or 4 judgments on sexual harassment matters. When I look at the matters and I write the judgments, I write the judgments based on what the facts tell me and what the law tells me. And I think of the 4 judgments that I have written, there's one involving the I think it's Home Affairs, where an employee was dismissed for sexual harassment, and I came in and I said, it's understandable why a commissioner would find that the employee was involved in sexual harassment, but taking into account the facts of the matter and the circumstances under which the conduct complained about had occurred, I was of the view that the employee could be given a final written warning and return to work. And obviously when I wrote the judgment, I was very much alive to the fact that the department might not be happy about the conclusion that I had arrived at, because there's, in my view, a misunderstanding that every case involving sexual harassment must be met with a sanction of dismissal. And I expressed a view in that matter that is not so. You must always be guided by the facts of the matter that's before you. So yes, I am an activist, but at the same time, I know I'm a lawyer at heart. And when I sit in these matters deciding which way to go, I apply the law, and I leave my activism at the door, so to speak.
Commissioner Moimang?
Thank you. Of being assigned to, during your clerkship, to work with the late Mr. Tim Mills.
Yes.
What motivated you to mention this, and what was the most beneficial experience of working with him?
Yes, so Mr. Mills is the director that I worked with when I was at Cliff Decker doing my articles, and I think the first 6 months I was allocated to him. It was, for me, just such a pleasure working with him. It wasn't just work, it was work and playing. He gave me opportunities to draft papers. He sent me to court with counsel. He sent me to consultations with clients, and I could see that he genuinely believed in my abilities to be able to do the task at hand. And obviously after the first 6 months, I then moved on to the other departments, but I wished I could go back to him. And I guess I can say maybe that's when my love for labor law developed, because I really enjoyed working with him. And I must say, when I was interviewed at CTH, they wanted to see if I was capable of drafting, if I drafted any heads, if I drafted any affidavits. And I just went back to the documents that I had drafted in the first 6 months of my articles with Mr. Tim Mills, and presented those to them at Chiddel's, and they were convinced that I was capable of doing the job of a labor attorney. So yeah, he left an impression on me, and yeah.
Thank you, Chief Justice. Thank you.
Commissioner Mangena?
Thank you, Chief Justice. Good morning.
Morning, Commissioner.
Good. I need to ask you a question regarding the matter of Payne versus Department of Education.
Yes.
You were dealing with a complaint arising out of unfair discrimination.
Yes.
Yeah. The referral was made in terms of Section 51 of the Employment Equity Act.
Yes.
And a point was raised that that's actually an incorrect usage. The correct section to use should be 1581G of the Labor Relations Act.
Yes.
Now, but in the course of your judgment, in paragraph 36 of that judgment, when dealing with that point raised by the respondents, you said that you are not able to dismiss or uphold that point and dismiss a case because the litigant relied on an incorrect statute.
Yes.
But then when you gave the order, you actually upheld that point, that the applicant relied on an incorrect statute. So I find that to be a bit contradictory.
Commissioner, if you can just bear with me. I definitely know that I did say that I'm not going to dismiss the review application simply because an incorrect provision of the Act has been relied upon. But what I said in the, if you can just bear with me to go to the order so I can see the contradiction that you are referring to.
At which page of the record is this?
Page 102, paragraph 1.
Yes.
It says the review application ought to have been brought in terms of section 158(1)G of the Labor Relations Act and not section 51H of the Employment Equity Act. So, excuse me, where is the contradiction?
In paragraph 36 of the judgment.
36.
Because the respondents had actually argued that that review should not succeed because it's brought in terms of a wrong act, but also a wrong section.
Yes, so in paragraph 36, I'm basically saying the review ought to have been brought in terms of section 158(1)G of the Act, but it was in fact brought in terms of section 50 of the Employment Equity Act. So I said it doesn't matter, the fact that they've relied on an incorrect provision does not change the fact that this court still has powers to review rulings issued by the CCMA. So I'm not quite sure where the contradiction is, unless I'm still missing something.
Oh, okay. So as you understood it, the fact that the proceedings emanated from the CCMA
Yes.
actually gave you the jurisdiction to entertain the review, notwithstanding that the applicant made reference to a wrong section.
Yes, so I did say section 158(1)G is a provision that allows the Labour Court to review rulings. But in that matter, the review application had been brought in terms of section 51H of the Employment Equity Act, which does say that if I recall, it's something to the effect that the court can also review decisions made in terms of the Employment Equity Act. But I was very specific to say where you are dealing with a section 10 claim, a discrimination claim in terms of the Employment Equity Act, that same provision tells us that you must process those disputes in terms of section 158(1)G of the Labor Relations Act, and that's what I did. So I said I'm not going to dismiss the review application based on a technicality, because whether you do it in terms of section 51H or section 158(1)G of the Labor Relations Act, the point is the Labour Court still has the jurisdiction to review rulings.
Thank you, Chief Justice. My second and last, if I may, and this one is very innocent.
I hope so.
If you are sitting as a labor court judge and you find that you do not have jurisdiction, do you dismiss the review or do you strike it off the roll?
Yes, thank you for that. I would strike it off the roll, but having said that, I do know that there's an LAC judgment that says sometimes judges dismiss the matter, but strictly speaking, it's not dismissing. You are striking the matter off the roll, except that in a case of jurisdiction, I don't know, striking the matter off the roll suggests that you can re-enroll it, but you can't re-enroll it if the court doesn't have jurisdiction. So, yeah.
Thank you, Chief Justice.
Commissioner Lukonyan.
Thank you, Chief Justice. Good morning, Ms. Kadide.
Morning, Commissioner.
I am impressed by you having achieved LLB with cum laude in my alma mater in Fort Hare, as well as, of course, what you have already told us you have done. And again, I see that if you are successful, you may be a walking encyclopedia, as it were. We've got 24 years. Now, my question to you, which I need to preface in this fashion. In South Africa, we do have many foreign nationals, Chinese, for instance, that were convicted here in Gauteng, and for having flouted our laws. And there were also some people that were involved in a building in Western Cape that collapsed. Now, my question is, in the stint that we have been involved in labor matters, did you come across any matter involving foreign nationals? And if so, are you able to share with us your experience, and as well as how you would deal with this matter, because it is a matter of concern to all South Africans, of course, including yourself as a South African. So can you just give us some indication how, whether you had such experience? If you have not, perhaps in future you come across a case of that nature, what would be your decision along those lines? Thank you, DJ.
Yes. Thank you, Commissioner. I think the question you're asking me is related to the question that the other commissioner asked me about my activism work and whether that's likely to influence me when I write my judgments. And the answer that I gave then stands. But having said that, I'm not aware of any matter that I've worked on where there were foreign nationals involved. Maybe they were, but if the papers do not refer to the fact that they're foreign nationals, I have no way of knowing that they are foreign nationals. But what I did indicate in my questionnaire is back in the day, there was a discrimination matter that I was requested to assist with through the SASLO Pro Bono office involving foreign nationals. And obviously when I represent people, I represent everybody, whether you are a foreign national or you are a South African. And when I sit as a judge, it's the same story. Whether you are a South African or you are a foreign national, I'm just applying the law. That's what I do. I look at the facts and I apply the law to the facts.
Hey there, folks. Today we're diving into some hot news that's got South Africa buzzing. It's all about Mrs. Candace, a Zimbabwean lawyer who's just been appointed as a labor court judge in South Africa. And let me tell you, not everyone's thrilled about it. So, who is Mrs. Candace? Well, she is a highly qualified legal professional from Zimbabwe who has made quite a name for herself in the world of law. She has got years of experience under her belt and a reputation for being sharp as a tack in the courtroom. But here's where things get interesting. She's not South African, and that's got some people raising their eyebrows. Now, you might be wondering, what's the big deal? Well, it turns out that appointing a non-South African to such a prestigious position has stirred up quite a controversy. Some folks are arguing that there are plenty of qualified South African lawyers who could have filled those robes. They're saying, why bring in someone from outside when we've got talent right here at home? But hold on a second, because there's more to this story. Supporters of Mrs. Candace are quick to point out her impressive qualifications and experience. They're saying that in a globalized world, it's not uncommon for countries to bring in top talent from abroad, especially when it comes to specialized fields like law. Let's break it down a bit. The labor court in South Africa deals with some pretty heavy stuff: disputes between employers and employees, unfair dismissals, you name it. It's a crucial part of the country's legal system, and the judges who sit on that bench have a lot of responsibility on their shoulders. So when news broke about Mrs. Candace's appointment, social media exploded. Twitter, Facebook, you name it, everyone had an opinion. Some people were congratulating her, praising her achievements, and saying this was a step forward for regional cooperation. Others, well, let's just say they weren't sending out party invitations. The debate got pretty heated, with arguments flying back and forth. On one side, you had people talking about the importance of giving opportunities to South African professionals and building up local talent. On the other, there were those who said that merit should be the only thing that matters, regardless of where someone comes from. Now, it is worth noting that this isn't the first time South Africa has appointed a non-citizen to a high-ranking position. It's happened before in various sectors, from business to academia, but somehow, when it comes to the legal system, people seem to feel extra strongly about it. So what does Mrs. Candace have to say about all this? Well, she's keeping it professional, focusing on the job at hand rather than getting caught up in the controversy. She has expressed her commitment to upholding South African law and serving the country to the best of her abilities. But here's the thing: this debate is about more than just one person. It's touching on some pretty deep issues in South African society. Questions about nationalism, about what it means to be South African, about the balance between local development and international cooperation. Heavy stuff, right? As the dust settles on this appointment, it's clear that it's going to be a talking point for a while. Some people are calling for a review of the appointment process, while others are saying we should give Mrs. Candace a chance to prove herself on the bench. At the end of the day, what matters most is how well the labor court functions and whether justice is being served. That's what Mrs. Candace will be judged on, not her passport, but her performance. So there you have it, folks. A Zimbabwean lawyer appointed as a South African labor court judge, and a whole lot of South Africans who aren't too happy about it. It's a complex issue with no easy answers, but one thing's for sure: it's got people talking. What do you think? Is this a step in the right direction for South Africa, or should they have looked closer to home? It's a tough call, but one thing's for certain: the eyes of the nation will be on Mrs. Candace as she takes her place on the bench. Only time will tell how this story unfolds. Remember, folks, in the world of law and politics, things are rarely black and white. There's always more than meets the eye, so keep an open mind, stay informed. And who knows? Maybe Mrs. Candace will surprise everyone and become one of South Africa's most respected judges. Stranger things have happened. That's all for now, but stay tuned for more updates on this developing story. Until next time, keep it real and keep asking questions.